Hi, good evening, everyone. Welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by a health and fertility lawyer, and looking forward to talking about all of that and all of the different things that she does. So, thank you so much, Lisa, for joining us. And perhaps maybe again, you could start by telling us a little bit about how you got into law and tell us about your practice.
Sure. Well, I got into law because I took a grade 12 law class in my last semester of high school, and my teacher happened to be a lawyer turned high school teacher. So he was just a phenomenal teacher that sparked my interest in the law. And I hadn't ever considered it before. I thought I was going to be a child psychologist until I took that class. But that was what set me on the path. So I did ultimately study psychology for my undergrad, but that was actually what sparked the interest. And it was the intersection of psychology and bioethics and mental health, all topics I found interesting, and law that led me to the overlapping area of health law.
Right. And so did you have that interest then right from getting into law school, or did you kind of
Yeah,
navigate?
I know some people have no idea what they want to do. I was the opposite. I knew when I was 17, I wanted to be a health lawyer. So I started throughout my undergrad trying to craft that path and choose a law school based on the health law programs and look for opportunities. So I worked in a hospital the summer before law school. I worked in a research ethics office. So that was very much the plan. And then I tried to craft a major as much as one can in law school and create health law opportunities. So joining an opportunity to represent a client before a tribunal, a health tribunal, trying to get published, make every paper a health law paper. Even like in family law, I made my paper about access to assisted conception. It was sort of the blend, which was my introduction to fertility law, was just trying to make everything about health law as much as I possibly could. And then I was very lucky that I ended up landing a job at a health law firm right out of law school.
All right, so let's maybe tell us a little bit about that and how that kind of transitioned you into what you're doing now.
Sure. Yeah. I mean, I was very, very lucky. There are more opportunities now for aspiring health lawyers than there used to be. In terms of right out of law school, I do see more. There just actually weren't as many firms then. So I was very lucky because there were hardly any of these kind of boutiques that do. There are more that exist now. So I not only was that a great opportunity at the firm, but we served hospitals, long-term care facilities. So it was an opportunity to see how law worked from the perspective of advising organizations, because now my practice is quite different. So it was nice to get that perspective and really enjoyed that work. I also was given a great opportunity as an articling student to do a secondment, which is essentially a placement. And so I got to work at the Center for Addiction and Mental Health, a Toronto psychiatric facility. So spending 2.5 months within a hospital environment and seeing what it's like for in-house counsel and responding to inquiries from psychiatrists and getting that experience was amazing. And although it was relatively short, 2.5 months, it really actually shaped how I practice law. And it really created this very practical lens where when I give advice to clients or really do anything, it comes from that experience of training my brain to think, okay, the law is, very abstract, but how can this advice be turned into something actionable that doesn't require my client to unpack the law? I kind of get right to the point for them. So that was a phenomenal experience that I highly recommend anyone do as a comment if given the chance.
Now, from there, did you what made you kind of then go into eventually starting your own practice, or was that kind of always in the cards to begin with, or how did you lead on that path?
So there were a few experiences that I had working for institutional clients where I started to notice a theme of family members being, how I've often phrased it, as left in the dark, because that's really what it seemed like. And as a hospital lawyer, there's some limits on what's appropriate to say or do for a family member, but there were times where I saw family and I thought, I wish that person had a lawyer. Like, there are more rights. So one example was I was at a consent and capacity board hearing, and I was probably just an articling student. And I was there on behalf of, with the senior lawyer, and we were there on behalf of a long-term care home. But some of the parties involved were self-represented family members. And I just was watching how it unfolded. And one particular family member, I just thought, if this person had a lawyer, he would have such a voice at the table that I felt like he deserved but didn't have and didn't know he had an opportunity to have a lawyer. And then a couple times I was actually contacted by other lawyers who wanted to send referrals our way, but it would have put me and the firm in a potential conflict of interest because it was a family who had some business with the hospital, whether it's a complaint or just wanting advice. And so a couple times that actually happened. And I thought, is there something here where I've been contacted a couple times about potential family caregiver files. So it was sort of a bunch of different things that created this concept of what I now call family health law. But a big part of what I do is serving family caregivers who are navigating the healthcare system, advocating for their loved ones, trying to get access to care or better care, or just to be heard. Like often what they're asking for and seeking is so minimal, they shouldn't need an advocate, but they do. And then that bleeds into the consent capacity work that I've always enjoyed and find interesting and rewarding, which can encompass consent capacity board hearings, but for the family members, guardianship work, and then advising people who are in the role of acting as a decision maker for another person to help them understand that their duties and obligations and all of that.
And so then what was it like, and then kind of making that leap there and starting your own practice, and what kind of, from getting started, getting set up, how did you find everything? Maybe you can kind of, give us sort of an overview.
Yeah, I mean, it's very scary. You don't know if it's going to work. You have I had no clients. So it's definitely intimidating. I kept my cost as low as possible. And I suggest other people do the same. Like I didn't buy, fancy anything really. It was just sort of what's the bare minimum that I actually need to spend to make this happen. And then I spent time going down to the Law Society. They have books there. So instead of buying books or even attending expensive professional development, I went down to the Law Society and accessed those materials for free. So things like that were, I didn't pay for any advertising. I used my time instead of money. So writing and speaking and kind of just getting out there, networking, doing all the things that didn't cost money, I did. So that was part of it. But it was the idea of starting my own practice was less intimidating because I do have relatives who have their own businesses. So the leap to entrepreneur in itself wasn't completely overwhelming. And I did not have children at that time. And that was actually the back of my mind too, that if I'm going to do this now before I have kids is probably the easier window of time versus later in life where I might feel like it's too late and I don't feel like I can make that transition.
Okay, so let's kind of talk about your practice, and again, as you said, when people say health law or fertility law, they're often, well, what is that? What are the kinds of things that you do in terms of your practice? I know you talked about the consent and incapacity board, which we can talk about as well in a bit. But tell us kind of what are sort of the different types of matters and files that come across your desk for those, especially my students who may have no idea. Well, what area of law is this, and what kind of things do you practice in?
I can tell you what I do, but I'll also give the caveat that my practice is highly unusual and not reflective of the typical health lawyer. So I got to do the typical health lawyer thing. I got that experience. And so that I can maybe speak to as well, because that's probably more representative of what health lawyers do, because I have such this little niche that isn't what most health lawyers do. So a lot of health lawyers work for institutions that might be in-house or private practice, but the client is an institution like hospitals, retirement homes, long-term care homes, family health teams, dental practice, but very much clients who are organizations, and they have so many needs. They have the corporate needs, so incorporation or incorporating a professional corporation, employment contracts with their staff or other contracts. Bigger organizations have more involved and more sophisticated contracts that might involve contracts with researchers or other institutions. There can be mergers and acquisitions, and all the things that happen in the for-profit world can happen in the not-for-profit world, a lot of it as well. There's procurement, so basically following all of the government rules about procuring services for a hospital, for example, because hospitals are businesses that need so many different things. So there's tons and tons of work on corporate, commercial, and certainly labor and employment. There's so many health professionals that are unionized. There need to be experts who understand that. There's the privacy experts. Privacy officer is a job title. So people who are experts in privacy law. And those individuals are not always lawyers. If they're not lawyers, they will generally have some kind of legal training. But privacy officers deal with access requests for people who want to access their health record, or there's privacy disputes and judgment calls being made about who needs a record and why, and following all the privacy policies and all of that. There's people who focus on medical devices and a lot of the Food and Drugs Act and pharmaceuticals, so a very big regulatory side. I haven't had much to do with that area. And that's just even part of it. So it's really, really broad. Healthcare is such a big industry. There's so many pieces to it. So really most health lawyers have carved out some of their own kind of niche within health law. So my niche is fertility law, so helping clients build their families, and it's serving family caregivers. But there's a lot of people who really do kind of subspecialize because health law is just incredibly broad.
Okay, so then let's talk more then on what you're doing there, and for those who have, again, no idea what fertility law within that sort of realm there or subsect, what are the different types of things that that you can be working on in that niche area?
So on a typical day, I'm usually working on at least one fertility file that day, and that encompasses a lot of contracts for clients. So surrogacy, which is when somebody carries a baby for another person with the intention of the other person, called an intended parent, the other person being the parent at the end of the day. This is different from adoption because the whole plan of a person becoming pregnant is formed before the pregnancy. So surrogacy usually involves surrogacy contracts. Egg and sperm donation are also legal in Canada, and embryo donation as well. So I draft the contracts between those parties and give advice. And then I have some clients that are in the fertility industry, so they need various contracts or consent forms drafted or advice navigating weird issues that tend to come up in the health sector. There's just lots of weird ethical issues that can arise that intersect with the law and ethics. And this is part of why I so enjoy about health law, is dealing actually with some of those very gray zone matters and trying to figure out the best way forward for the client. So that's very much though about building families. So that's really, really rewarding when I get updates that clients, their surrogate is pregnant or they're pregnant with, an egg or sperm donor or a baby's been born. It's very happy law, and it's a really nice counterbalance to the other work that I do for family caregivers, which is rewarding, but not really happy. People are coming to me because they are in crisis. A very, very common file is somebody has a loved one with a mental illness and they're not being treated. Maybe they're refusing treatment, they haven't been diagnosed, or they won't leave their room, they don't recognize that they're ill. So it's this big question of, well, how can I help this person? Like, what's the law? How do I get them assessed or get them care? Do I need to be a guardian or not? So all of that, navigating the health system, which can turn into assistance with guardianship in some cases, often that's not necessary, or just helping them understand what rights they already have as a substitute decision maker under the Healthcare Consent Act, because sometimes people have more rights than they know, and it's about educating them, empowering them, pointing to them to the right sections of the law so they feel like they can advocate on their own. And I stay very much in the background, because bringing a lawyer in can inflame a situation and make healthcare providers feel very defensive. And that's not the goal. The goal is to get along and just create some kind of change. So very often it's equipping clients with, here's what you need to ask, or here's what you need to share, and here's how it can strategically be done to get some sort of result. So it's not about suing hospitals and suing doctors. It's very short-term, strategic, practical advice about solving some kind of problem in the very near future.
Okay, so since I think my paralegal students can appear before boards and tribunals like the consent and capacity board. So let's maybe start with that, and let's kind of look through like maybe like consent and capacity board 101 of someone comes to you and they have any of those issues you mentioned, and it's going to go to the board. How does it go from someone sitting at, I guess they won't be sitting at your desk as we talked about, but virtually these days now, reaching out to you and saying, hey, Lisa, I have this issue. How does it go from there to potentially before the board, and can it go beyond the board if need
So this
be?
is a very unique tribunal. It is unlike any other tribunal. It is a moving tribunal. So currently during the pandemic, it's by Zoom. As far as I'm aware, it's all Zoom. I could be wrong. Maybe there's some that have happened on site somewhere, but I've only participated in Zoom hearings. But prior to the pandemic, it was traveling board. So they would go to where the person involved in the case was. So they would travel to long-term care homes. They would travel to hospitals. So if I had to appear before the board, I was not going to their headquarters. I was going to the hospital where a patient was staying. So that in itself is very unique. The other very unique thing is the hearings under the Healthcare Consent Act, they are supposed to be heard within 7 days of the application. And the application is paperwork that often is filled out even before a lawyer is involved. There are rights, in some cases, there's rights advisors who will assist a patient to fill it out. And so now by the time other lawyers get wind of it, it's less than 7 days. And the board has, gets involved, reaches out, picks a date, but this stuff happens fast. I once prepared for a hearing in 2 days. And that was like preparing for materials. I had 6 witnesses that I had to draft questions for, and it was in 2 days. So just the speed of it is unlike any other tribunal. So you kind of have to go in knowing your stuff. It's not like other matters where you can learn on the job because you've got that breathing room. It's very much a hit the ground running kind of tribunal. So for anybody interested, I would definitely say watching hearings and learning a lot in advance and having a clear sense of what kind of hearing one would want to take on, because there's different types, and the board actually has on their consent capacity board website has different types of hearings, different forms. I don't do them that often because family caregivers don't go to them that often, or if they do, they're not a party in all cases. So sometimes it's just a bit of behind the scenes advice. When I do get involved, it's been hearings where there's a dispute about whether the substitute decision maker is actually complying with their duties. And generally that's in the end of life context. So there's some conflict with health professional, maybe multiple family members, about whether life support should be withdrawn. And so I've been involved in some of those cases. And then sometimes there's a dispute among family members, which person should be the decision maker for medical decisions. So in those kinds of cases, I've been involved, but most of the time I'm behind the scenes helping clients understand what to expect if they're going to be a witness, for example, but they don't necessarily need representation.
And so, I mean, is there it's situations, for example, would imagine, let's say maybe a parent and has two children and they're both like the decision maker, one's maybe one and the other, and they don't agree, right, onto maybe whatever the course of action might be, or treatment, or if it's end of life or something like that. Is that kind of where you would see it going to the board there to kind of be resolved, a type of issue like that?
It can, yeah, it can be, and it can be initiated depending on the type of hearing by different parties. So a healthcare provider can initiate the hearing. So a doctor might say, I proposed that life support be withdrawn, and the substitute decision maker is not consenting. I don't think that this decision is in the patient's best interest, so let's go to the board and get a decision. Or it could be a family member saying, my sibling is actually the decision maker, or we are both decision makers together and we disagree. I should be the sole decision maker. I'm going to bring this matter to the board. So it really kind of depends on what the specific nature of the hearing is and who gets to bring the matter. And then there's some matters family members can't bring to the board. I have a list that I've kept that maybe one day I'll be able to advocate that they change, but that's on the back burner for now. But there are some situations where I think family members should be able to go to the board, but they just don't actually have that right under the current Healthcare Consent Act.
And so, I mean, you hear about some of these cases where, again, the doctors or the medical team feel it's time to go, but the family is clinging to hope, maybe that there can be some miracle or some sudden turnaround. And what kind of, in terms of that decision there, in terms of how does that get weighed in? I mean, if the substitute decision maker is saying, well, why not? And isn't that what they would have told me, or maybe it was in their interest, or why don't we get a say in that? If or we get our say in it, why does sort of it even go to a board and it doesn't come out of our decision making?
Yeah, and that's what family members will say. I know my loved one best. I've had these conversations with them. I have a best sense of what they would want. What you will find if you look at and of course, many cases are not reported. The Consent Capacity Board only publishes the decisions if somebody requests reasons. So we don't actually necessarily know the whole body, but of what is reported, overwhelmingly the family members lose these cases. Even going into that, some family members will say it's worth trying because it will give me closure. I'll know I'll have done everything I can. Or, hey, the process of a hearing, we're looking at 7 or more days. That buys me a little time to see if my loved one changes. So there can be reasons some people will pursue these cases despite the odds. But a lot of these cases, it comes down to there is no prior capable wish that's known and applicable to the circumstances. And so looking at the best interest factors, weighing those, the healthcare providers generally will only propose withdrawing life support once they've consulted with colleagues. They've, in most cases, given some time to see what happens. So in their view, it's in the person's best interest. And the board does not say quality of life over quantity of life over quality. They're very comfortable making decisions about this person probably wouldn't want to live like this, despite the family saying otherwise. What happens in many cases is the family, they really just can rely on recollection, or those vague sense of like, I know what they would want. I've had these conversations, but they don't, when grilled on it, they don't remember the time, place where they had those conversations. Or maybe it wasn't an exact conversation, but they just know their loved one so well, they know what they would want. And that is not always considered persuasive enough. So I think if there's a case where there's a written prior capable wish, it would have a much, much better chance of succeeding, because that is the obligation of the substitute decision makers, follow that prior capable wish. But in most cases, there's an absence of a written wish, and families testify about what they believe the person would want. But in the majority of cases, that has not been persuasive to the Consenting Capacity Board. And in these cases, usually it's considered by the healthcare team that continuing life support is futile and the person won't get better and won't, in many cases, even wake up. Or if they do that, they would be, their quality of life would be severely compromised. So that's usually the position of the physicians.
Okay, and I guess on the reverse end, like what if someone had said, I don't want to live in this way, right? I mean, if I'm going to be in a vegetative state or whatever, and they told a family member, and maybe they didn't have it written down, as you said, but they have that conversation, and the medical team's like, well, there's a chance that there could be a recovery still. I mean, do you see it in reverse where someone's ready to sort of pull the plug?
I don't think I've ever seen that, because what I've really only seen is healthcare team gets to the point that they propose withdrawing, and now it's a treatment decision to be made. So here's a treatment decision, removing life support. So as it's been kind of tabled as a treatment decision, now do you consent, do you not consent? And if there were evidence of a wish that that's not what the person wanted, and the substitute decision maker, for whatever reason, doesn't consent to remove life support, the same hearing could happen. The physician could say, well, I'm going to bring an application to the consent capacity board, point to this evidence of the prior capable wish, because that's the duty of the substitute decision maker, is to follow that wish. And I would have a strong guess that that physician would be successful in that case if there was actually proof of the person's prior capable wish. The family member could try and argue that they changed their mind, or they have reason to believe they changed their mind, and the most recent prior capable wish does prevail. So they could say they signed it, but it was so long ago, I had conversations after that. So there would be some arguments that they might be able to make.
Now, and one of the things that you said that was very unique, there's the quick turnaround, right? I mean, normally for civil litigation, let's say you're looking at years between an issue before a claim is filed, before the matter goes through litigation, through all the stages there. But here you're often, again, within days, having to be ready. You give that example there of 6 witnesses. And how do you prepare, given that you have situations where, I mean, assuming you have your other clients as well, but where something like this can happen, and you got to kind of drop everything and be able to organize, and you don't have enough time to even gather a lot of the evidence, because by the time you would pick it up, it's going to be over. So how do you kind of organize that for law students and lawyers who are more wanting to have things kind of more laid out and being on the fly and preparing for something like that?
I mean, if I don't think I can actually prepare, I have turned down a file before. That's an option if I don't think I can competently do it. So I have had to turn it down. I also don't have so many of these because the family members aren't usually looking for representation relative to patients who are looking for lawyers all the time, challenging a finding of incapacity or being held as an involuntary patient. So there are patient lawyers, that is their practice, that's their routine. So they have to make it work because that is the nature of the work they do. But yes, they have to do a lot of work to prepare. They have to read that patient's chart, but there's going to be certain templates, and they know the law very, very well. They do it every day. And there's going to be certain systems and templates they have developed. Like a lot of the questions are going to be able to be used from one to another. For example, asking a psychiatrist, what is the test for capacity? If it's a case about capacity. So some of the questions can be repurposed, but then they are moving like lightning to get access, to their client, get the records, and do a lot in a short amount of time. So in some firms, there might be multiple lawyers, so they can juggle that. Otherwise, it's a matter of sometimes turning things down and finding a referral if it's just not possible.
Okay, so let's maybe switch gears a little bit, because I know you practice infertility law there, and perhaps a question that comes up there is, well, what happens when in a surrogacy, right? That someone comes up, they have this, okay, well, you'll be our surrogate. Can they, do they often have a contract that they draft out at the outset? And what happens if the surrogate now, after giving birth, wants to keep the baby? Is that something that does come up, and how does that all work out?
I've never had a surrogate client or intended clients have that happen. This is something that is that's the question. But practically speaking, that is so, so rare. Most surrogates they've gone through some kind of screening process. If they use a surrogacy agency, some agencies are quite rigorous with who they'll accept. Some, they all have their own way of doing that, but some are quite rigorous. They go through counseling. Fertility clinics require that they speak with a mental health counselor. So often somebody who's a social worker or psychologist, to make sure that they actually are emotionally kind of ready for this. It's a huge deal. They usually are done completing their family, have gone through pregnancy, so they have a good sense of what they're consenting to. They get their own lawyer. They have independent legal advice. So there's a lot of things that happen to help make sure that people aren't doing this if it's not a good fit for them. And then also in Canada, it's altruistic. So people aren't doing it for the money. That is one, it's a contentious debate, should surrogates be paid? But one argument against commercialized surrogacy is, will surrogates do it for the money and then be likely to change their mind because their heart wasn't in it for the right reasons, etc. But in Canada, it's altruistic only. And that is a common concern for those outside the field, but for lawyers in the field, it's something that most of us have never seen, or if people have seen it, it would be so incredibly rare. And most surrogates are not genetically related to the baby that they're carrying. Usually the egg is from a parent or a donor.
I guess it just makes for like TV show specials there that everyone thinks that happens there. But then in terms of then just if you have a donor there, in terms of having like a contract and organizing all of that, of what, the how everything's going to be done, how would you, is that something that you would certainly advise people to make sure that they have everything cleared up going in?
Always.
And maybe you could tell us kind of what would be going into all of those types of contracts.
Yeah, I mean, a contract is so important. I believe I've done at least one of my YouTube videos have been about the importance of surrogacy contracts and blogs, because it's so important. Many fertility clinics require it to even proceed with the medical steps. So that would be a deal breaker to not have one. In some provinces like Ontario, it's actually cheaper to have a contract, as odd as that may sound, because to register the baby and get a birth certificate after the fact, we have two different paths. One is sort of the cheaper, faster path, and it's paperwork, but it doesn't involve court. Non-court, cheaper. And that path is only available if certain conditions are met. Surrogacy contract is one of those conditions, and independent legal advice. So if you can satisfy those conditions, it's faster. Somebody who does not have a surrogacy contract must actually, in Ontario anyway, has to go to court and get a court order and then go and submit the paperwork for a birth certificate. So it actually ends up being more expensive to not have the contract, because the process of hiring a lawyer to go to court and bring an application is so much more extensive.
Now, you mentioned just there your vlogs and videos and certainly courses there. So maybe it's probably a good segue into that, and tell us a bit about how that all came about and what are some of the things that you have on there, and in terms of access to justice, of course.
I'm only laughing because it's a real lesson, and done is better than perfect. I had planned to do YouTube videos in 2013, and I did not do them until 2020. 7-year delay, because I was striving for perfection. I wrote scripts and I thought I was going to borrow someone's space where they have a teleprompter and a green screen, and the level of work to do that is so big that I did not do it. I had too many other things to do. And so done is better than perfect. So in 2020, things were slower during the pandemic. I thought, okay, I'm going to start this YouTube thing. And I got a little more comfortable on video. Earlier in the pandemic, I did a couple little videos I posted in, our Facebook page, things that just kind of felt, I tried TikTok, wasn't really for me, but I tried it. So I did enough video to start feeling more comfort. So I started YouTube, and truly done is better than perfect. I just put the videos out. I figured out some editing myself. I didn't keep that up. I now have high school co-op students doing the editing, or my assistant knows how. She's great. It just took me too long. But I did the first couple, and if you look back, they're not good videos. The lighting is terrible. The editing is terrible. But I got it done. And that was the goal, was like, my goal is just do it. And now I do put one out every week. I film them in advance and have more of a rhythm going. And you can make the little intro and outro. I made them for free using Canva, so you don't need to spend a lot of money. And most videos are just one take. Come up with the topic, and I have a running list of topics, but just one take usually, and just speak about something I know, so it doesn't take too much of my time. Once in a while, I'll just, check the status of something, but most is just on the fly. And so by making it as easy as possible to actually do it, I'm doing it. And then YouTube is kind of nice because it can be shared on a website and LinkedIn and Twitter. So it's easy to use sort of one piece of content that can go multiple places. And a lot of the videos, the goal is, like, if anyone's thinking about YouTube, I suggest thinking about your strategy. My strategy was not be a YouTuber. The strategy was provide educational content, hopefully helpful for some people, and videos that we can send to clients and leads. So now people contact us and we share videos with them. It's even part of our intake process. So for example, we have a video, what a donor should know before independent legal advice. We send that video. So that way they have an opportunity, if they want to be more prepared before the meeting, they can watch that video. So some of it really has to do with answering questions for leads, especially people maybe it doesn't make sense for them to hire us. We can at least point them to a couple of videos that answer really what they were looking for. So we actually use it more on the back end in many ways with clients and leads, and providing them with information.
Yeah, that's excellent. I just saw one here. I think, obviously the hot button topic of in all around the world, for that matter, but who consents to the COVID-19 vaccine? Especially now with it opening up to 5 to 11-year-olds. I mean, the big difference there from the 12 to 17-year-olds versus the 5 to 11. So maybe I could just throw that out there, and you can kind of tell us what you share with.
I mean, I don't think I'll cover everything now. So anybody who's really interested, maybe read the blogs. I'm sure I'll miss some things. I will say I posted that, and then I went like this because it's just so controversial. I've been reluctant to put too much content out because what the law says is not what everybody wants to hear, and was a little nervous about backlash. So I tried very hard to make the blog very fact-focused, I actually had multiple people read it, including people who chose not to have their child vaccinated. So tried to get people with different perspectives reading it. So hopefully that comes through about that it's very focused on the law and just sort of things that I've been wondering about. And I thought maybe I could put something out there that is interesting and shares, somebody in the area of consenting capacity, what I've been thinking about all of this. The short answer though is in Ontario, there is no age of capacity. So technically, legally, there isn't an age, there's no minimum. However, that's not to say 5-year-olds are necessarily being asked to consent to their own vaccine. It just means there is no age. So what practically happens outside of the vaccine context, Stephen, is people will usually, healthcare providers will generally get consent from a parent. And at some age, there's no one magic age. At some age, children become young adults and start making their own healthcare decisions. And there is a presumption of capacity, but there isn't one age where that happens. There are people who are seniors or middle-aged that might be incapable. It's all about this test for capacity. And so there are some school boards that put out policies that for kids 5 to 11, parents will be asked to consent. And I just thought that was so fascinating. Practically speaking, it makes perfect sense because it's now easy. You get the parents' consent. It's the same rule for everybody. Legally speaking, that's not exactly what the Healthcare Consent Act says. Could there be a capable child, 5, probably not, 11, maybe. And so it's just been really interesting to watch this unfold. And it might be that it works out. And part of what I talk about, the ethical dilemma here, which is about sort of the appropriateness of infringing on a child's rights if they are capable but have no knowledge that there's maybe recourse, and kind of exploring that. But I'm not really advocating one way or the other for that in the blog, which is kind of laying out some of the interesting legal issues, and then the recourse if somebody is in conflict with the other substitute decision maker, for example, how it could potentially play out, or in conflict with a healthcare provider. But much of that is just me finding it interesting to write, and I actually don't think many of these things that I wrote will actually come to fruition. They're technically legal recourse, but I don't think we're going to see much of that actually happening.
Now, I mean, while it's certainly about the COVID-19 vaccines, I mean, that would apply for other areas of health law too, right? I mean, if someone wanted, a child thought they can do a surgery, any kind of surgery, and the parent may have disagreed, right? I mean, so you're saying there's no kind of line at like 12 or 14 that says, okay, all 12-year-olds are presumed to be competent and to have the capacity to make those decisions. It's more contextual, and you would look at the different factors, right? So I mean, maybe you could take a look at that.
It is decision specific. So a 12-year-old maybe isn't capable of making a decision about surgery, but maybe the decision is something else that's much lower risk, less significant for their overall health, and maybe their doctor believes they're capable of that decision. So it's very decision specific. It's not, well, they're capable, so this 12-year-old decides everything for themselves. It actually can be completely dependent on the decision, and capacity can fluctuate, which with children, it might be that they go from incapable to capable, but as people are older and they develop health problems, mental illness or dementia, or have a traumatic brain injury, it might be that someone becomes incapable and they later can actually regain capacity. So it can fluctuate, which makes it very difficult to actually kind of pin down when is the moment someone's capable in cases like that. It makes it very, very difficult from a practical perspective sometimes.
Yeah, I mean, and by the time, you may have some of those things, their capabilities could have changed, right? And they may have been capable at that point, and then they are no longer capable. And then when you're going and assessing whether it was or not, it'd be difficult to kind of pinpoint it unless you have like a video recording or something that you can point to and say, look,
it's a struggle. It's a struggle. And my clients are family caregivers. So they might say, well, last time my son was in the hospital, I was the substitute decision maker, but this time nobody's talking to me. Like, am I the decision maker? Am I not? Am I entitled to information? I don't know where I fit in all of this. So the fact that it can change makes it really difficult for people who actually have legal obligations and some rights, and they don't necessarily get told anything. And so there's sometimes that lack of clarity.
And is there a process there in terms of being the substitute decision maker in a situation like that? Or is it just like, do they go to both the parents? Or
So this is another challenge my clients have faced, is the Healthcare Consent Act has a hierarchy. So, guardian of the person, power of attorney, representative appointed by the consenting capacity or its spouse or partner, parents or kids if they're 16 or older, or Children's Aid Society, access parent, sibling, any other relative, PGT. There's a list. You go from top to bottom. It's default though. It's just, where do you fall on the list? Okay, you're the substitute decision maker. Are you capable, available, willing, right age? You're it. There's no paper. And so I've had so many clients over the years. Again, this is an example of work that I don't think I should have to do. Nobody should need to hire me. But I've written letters saying, my client is the substitute decision maker. Here's the law. Here's where they rank. I confirm there's no person above them. They're the decision maker because they've been asked to provide the paper, but there is no paper unless there's a power of attorney or guardianship in some cases. But the people who just have that role because by default of their relationship, there's no paper. And that is something I hope more health professionals can learn about, because it becomes a struggle that shouldn't have to be a struggle. It's just that is already in the law.
And then if there's two guardians and they're not aligned with each other, I mean, then that throws everything even further off, right?
If decision makers don't agree, it can unfold in a bunch of different ways. It can be that if a decision is quite imminent, if they can't decide, public guardian and trustee, a government agency, can be contacted to make the decision for them. So that can happen. Or if they're not actually the guardian, but they're lower level, someone could seek guardianship and try to outrank someone else on that list. So maybe parents are deciding together or siblings are deciding together, they can pursue, go to the proposed representative route and try and become appointed by the consent capacity board or seek guardianship. So it can be strategically, how can I rank higher? Or if one person who's the decision maker sides with the doctor, the doctor could choose to bring the matter to the consent capacity board. In theory, they probably wouldn't. They'd probably just go to the PGT. So these conflicts can unfold in a variety of ways. Best ways when they don't involve litigation. Mediation can sometimes work. Bringing an ethicist in can work. Negotiation, trying to understand each other's point of view. Bringing in sometimes a medical expert to give opinions on things. So I was involved in a case where there was a conflict. So we just contacted the doctor and said, what do you think is actually in the patient's best interest? In that particular case, he didn't have a strong preference one way or the other, but it was worth the shot to try and shed more light and get more facts to see if one side maybe was not understanding the circumstances.
Yeah, I'm glad you brought up like the ADR process there. I mean, I know as much as you go back to law school and everything was like trial advocacy and litigation. I mean, the reality is, most of these would go through negotiation and mediation and perhaps even arbitration, I guess. But what in terms of preparing for situations, I mean, again, a lot's on the line. Obviously, people are very passionate on their positions. How walking through, some of your clients through, trying to resolve this, because ultimately everyone, wherever their opinions are, they think they have the best interest of the the patient at stake, right? And it's just maybe they think differently than the other ones. So how does that kind of play out in terms of trying to get some resolution, whether it's an ethicist, whether it's a medical expert, or whoever, or even if it's just the two parties there, in terms of getting to a resolution?
Yeah, so I find the work that I do fascinating for that reason, because everyone feels they're doing the right thing. It's not that you wronged me and I want money. And this is true, the health providers and the public guardian and trustee and the family members, everybody whoever's involved, they think they're doing the right thing, because sometimes if we don't have a person's wishes, we are all guessing what the right thing is and what they would want and what's in their best interest. And so years ago, again, I think I was probably an Article student, and one of the earlier consent capacity board hearings I went with, I was so surprised at lunch, we all ate in the same cafeteria table in the long-term care facility. It's like, right, we're all sitting together, like we're litigating in there, but we're eating lunch together in here. This is how it works, because there was the doctor and the family member that had an adversarial position, and he was trying to take care of his patient, and the adult child disagreed with the decision, and there we all were at the table together, and I thought it was so odd. But there was a certain amount of mutual respect there. It was just seeing things differently. And so when it's family members too, that's something I always try to keep in mind with my clients, is what are we going to do or not do? Like some clients will say, I'm going to let that go. I'm not going to go to court with my sister because that would devastate my mother. And although I'm trying to help my mother, that's actually not consistent with my mother's wishes. So I want to go to court, but I'm not going to. Or if we go to court, for example, pursuing guardianship, we will thoughtfully draft things, and maybe there's things that technically they would help the case. They would make the sibling look really bad and not be guardian, but we talk about what's the damage to the relationship, and is it worth inflaming the situation by giving that example? So I find there's these sort of relationship aspects that play into the strategy, and then it's up to the client often of, do we go there? But sometimes we don't go there, even if we have certain examples or statements, because we're factoring in the relationship, and people, if they are in litigation with their sibling, that's hard to come back from. So how can we do the least amount of damage possible, or not pursue it in some cases? So I've had some clients just say, I'm walking away, and it's really painful for them. And sometimes they say, I don't know how I'll even see my loved one anymore. I've had multiple clients actually say that, which can be hard to understand if you're not in it, but they say it's so painful. I'm just going to have to walk away and pretend my loved one died. And I have heard a few people say that, because this idea of kind of watching what they perceive their loved one in the hands of another family member, and they believe will be not treated the way they should, is just so difficult. So the whole area is very unique in terms of the kinds of dynamics at play between the parties.
And with those dynamics, and certainly it certainly will play, hopefully not so much, but I mean, I think as any practicing lawyer, I mean, you're also dealing with your own, taking care of your own self, right? Your own mental health, and you're dealing with a lot of these issues there coming from, where a lot of emotions are at place. So what can you say in terms of maybe, for yourself there, how do you kind of navigate everything and then be able to go back and, spend time with your own family there, and leave work kind of where it stands, and then continue on, especially over the last couple of years of the pandemic, which throws its own things on there. Anything you can share with students or people looking to get into a field where there's a lot of emotions, a lot at stake?
Sure. And I was concerned about this when I started my practice. I did a Myers-Briggs assessment, which I highly recommend for anybody watching, because there's some free ones online, and whether they're the exact clinical standard, maybe not, but I have found them very insightful. And there's 16 different personality types, and some of my friends and family have done them, and it's very specific. It's not like a horoscope. So it's been very enlightening. And I was worried that my empathy would be a problem, because if I'm too empathetic, it's not even about losing objectivity, but like you say, it's sort of the toll. And I am mindful of that. And I do think, like, over the years, it definitely, I can feel it adding up. And how I'm addressing it in a few ways. One, I've now been out of law school for over a decade. I'm at a point that I can start to look at where can I actually make a change in the system. And I've been keeping a list since my early days of where I think the law can change and be better. But now I'm actually at the point of joining groups and trying to have my voice heard. And my voice is really speaking on the collective of the family caregivers I've been hearing, and sometimes in fertility space as well. So that is advocating for change in the system. I have submitted proposals when bills have come out about surrogacy, about medical assistance in dying. I put something together and put a submission on that. So when I sent to Health Canada, I don't know if I was the only voice, I probably wasn't, but I saw a change in a different draft, and that was great to see something maybe that I wrote made a change. So trying to channel it into positivity. I also have a husband who's a paramedic, so he understands my world better than anybody, really, even better than a lot of other lawyers, because so much of what I'm dealing with, he deals with it just in a very different perspective. And he also has that same challenge of, being, and more so because I'm often, it's on paper, computers, talking to people. He witnesses things that I won't give any examples, but people develop PTSD in that job. They're quite horrendous things that he witnesses. So we are each other's sounding boards, and we are able to share stories and be a great support for each other. So that's great. And then fertility law is my other balancing. So I do work that's so heavy, end of life, mental health, and some of it's really devastating. And then I get to help people build their families. And for me, even though that might seem like a confusing mix, that they're quite different, there's a balance in that of balancing it out with some work that's just purely positive, and really rewarding in a very different way. And then, trying to take care of myself, try to exercise, those sorts of things too. Yeah, I would say it's a collection of those things.
Okay. And then on that, in terms of looking at all of that, now beyond your practice, you also do a number of other things that we talked about, the vlogs there, as well as the videos and the posts there. But you mentioned as well, you've done some teaching, and you've written a chapter there in a book, and as well as obviously the blog writing there. So what kind of got into, again, branching off? You have your practice and you want to have all these other projects there, and how have you found doing all of the different things?
That's the beauty of being your own boss. You decide what you can prioritize and what you can have time for. So that's definitely a help. Although when I was at a firm, I did join a board. I was teaching and checked in with my firm in advance. I suggest doing that, checked in that it was okay. And the board was in the evening, and it was a 10-minute walk from where I worked. So it didn't impede with, but I also made sure, there's not a conflict of interest. So good to check with your employer for doing some of these things. And the teaching, when I first started, was in the evening. So I just find a lot of that work is very rewarding. And my personality type in the Myers-Briggs is actually called the teacher or the giver. So writing and teaching students, like writing the book chapter, all of that is just rewarding. It's like nourishing for me, and it's my day job. Just doing the work isn't enough. So it's just a really good fit, and I love teaching students. So I used to teach, there was a course at Osgoode, a lawyer's negotiator is the name of it. And I was part of the teaching team. And then in 2016, I became an adjunct professor at York in the Faculty of Health. So I've been teaching healthcare law since then. So I'm just wrapping up one semester. I'll be teaching 2 classes next semester. 2 will be harder to juggle for sure. I did it once before. That is more challenging. One is easier. But yeah, I find it's a good fit, and it keeps me on my game. There's certain areas of law that I don't practice, like public health law. And because I teach it, I stay on top of it, because every semester what's going on with it. I'm looking at, the Quarantine Act that I don't normally look at. When pandemic started, I was very familiar with the Quarantine Act. I knew it existed and some of what it said because I teach it. So a lot of what I teach is related to my practice, but the areas that are outside, I actually find it makes me a more well-rounded lawyer. And I even learn about new cases because my students do a case summary and they pick cases. And sometimes I read one thing, wow, that's a great precedent. So it's rewarding to teach, but I do learn from the experience as well.
Yeah, I mean, and I guess next semester I think they're back in person, I believe. So how have you found kind of doing the remote with respect to teaching, and now kind of going back to in person?
Well, like everything, pros and cons. I mean, the con is I don't engage with my students in the same way. I love just sort of walking around, break them out into groups, listen to what they're saying over here, and the students coming up after class and doing mock hearings. I would actually sometimes surprise them and put tables together, and they went in little groups, and then I surprised them and we did a mock consent capacity board hearing, and you're this person, and just kind of the spontaneity and the discussion. So that's missing, and students usually keep their cameras off, which I don't feel the connection. The positive though is I've restructured the course. And so rather than a 3-hour lecture, which is a lot of information all in one time, I switched to 1-hour lecture and then all different things. Some 10, 15-minute pre-recorded lectures, and here's a different reading in a podcast and some exercises that are practical. And so I've kind of restructured the course in a way that might help it be more well-rounded and stick, versus at some point in the lecture if people were tuning out because it was so long. So I do think there's a lot of benefit of more bite-sized content. So I now need to figure out what the best way forward is, because I think that bite-sized content, I don't want to lose that. But all of that plus a 3-hour lecture might be too much, because that would be way more work than it ever was. So I need to find out a new balance going back into the real world.
That's great there, and I think it's going to be interesting because it's like coming out of hibernation after 2 years. I mean, again, I have the same issue that coming next year we'll be back in person, and it's like how all the things that worked remotely. I mean, how are you going to kind of keep that there, but now take it to an in-person class? And it's certainly really interesting. And again, the thing there is everyone's going to be a little bit different with it. I see David here has a question. David, you can either unmute if you want, or you can type it here in the chat, whichever you prefer.
Hey, JP, how are you?
Good. How are you doing, David?
Good. So I just have a question. What is your favorite aspect of law? Like, what do you like, torts, or do you like like what's your favorite aspect?
I mean, I would summarize it by saying health law, even though some of my practice bleeds into other areas. So my guardianship work really bleeds into estates. That's usually not health lawyers doing that work, it's estate lawyers. But I don't do traditional estates law. I don't draft wills. I don't litigate wills. My surrogacy work arguably bleeds into family law. When I have gone, mostly I don't need to anymore, the law changed, but I have one coming up where I'm going to court in relation to a surrogacy matter, and I did another one this past year. That's family court. So there's this family and estates kind of blend, but at the core, it's health law for me. So I really did enjoy advising healthcare institutions. I thought I would hate anything corporate commercial. It sounded dreadful in law school, but in the context of clients that I cared about and issues I found fascinating, it was very different. So health law in general, I think I could be happy in many, many different kinds of healthcare law type of roles, whereas many areas of law, I would soon rather just leave the practice of law than be like a mining lawyer or many of the other divorce law. There's many areas I wouldn't want to touch with a 10-foot pole. They would not be a good fit for me.
As well, Lisa, we were just chatting about remote and going back in person with respect to teaching, but now in terms of practicing and what you've seen over the last almost 2 years, I think you told me before that you've had one client come in person there. Is that kind of the way to go in the future, or do you think that people are going to want to come back and meet in person, or you're going to change your opinion on that, or how in terms of just, I mean, certainly capacity board or court itself? I mean, some cases have been remote by Zoom. Some, I guess you may go back to like the hospitals and stuff. But what are your thoughts on all of that in terms of the remote practice and working remotely beyond the pandemic, let's say?
Yeah, I mean, I think it's here to stay because a lot of clients now know how to use these tools that never needed to before. A lot of firms now can accept online payment that didn't before. So I don't think that's going to go by the wayside. I think it's a great way for people who run their own business to keep overhead down, because there are places where you can go and just rent a space by the hour if you need it for those times. But I think that fusion model, that hybrid model, maybe being available for clients if they want to meet in person and online, for a lot of people will be a great fit. I already had my office here before, so I'm not going anywhere, and I like working out of the home. But I really like meeting clients virtually. I find it works. It saves them the commute. And for me, it gives me the flexibility on any given day to say, you know what, I am going to work from home today, or I am going to wear fleece leggings like I'm wearing right now because no one will see them. So the sort of the feeling of flexibility around it, I have really come to like. And I feel like I have been able to connect with my clients as much as online's not the same. I do feel like when I talk to my clients, even on the phone, like I get their story, I get where they're coming from, and I don't feel like a lot has actually been sacrificed by doing it remotely.
Perfect. So Lisa, thanks so much for taking the time here, joining us, sharing all of your insight. I was wondering if you have any final words of wisdom for any of the students here listening. And thanks again for joining us.
Sure. And I actually, one of my videos was tips for students. So, but my big tip that I like to share is grades aren't always as important as you think they are. There's a lot of other things that are very important. When I went to law school, obviously I went in with very high grades for my undergrad, but I knew the chance of being a straight A student in law school with the curve and everything was unlikely. So my strategy was, I'm going for a straight B, which is the most likely outcome no matter what my effort, and let me focus on other things. So those other things, joining clubs, being a peer reviewer, being part of moots, and getting papers published, and volunteer work through pro bono. And so for me, it wasn't grades that mattered as much as getting real experience, making real connections, and having now hired as well. When I've hired, I've had 2 articling students before. I also did not hire based on their grades. I hired based on, are they passionate about health law? And I've spoken to other lawyers in other fields who say the same thing about family law, for example. So the demonstrated interest in an area and some practical experience can all count for a lot. So I know it's the time of year of exams, and it's just natural as a student to be so fixated on grades. But often from the employer side of the table, grades are not at all as important as they seem from when you're a student.
Okay, perfect. So thanks again, and I wish you all the best. And thanks for everyone for tuning in. Take care.
Bye, everybody.